Hi, I'm Susan Seabrook. I'm a tax partner with Evershed Sutherland, and I'm here with Jim Mastraccio, also a tax partner with Evershed Sutherland. And we're here to talk to you today about FBAR reporting. Basically, if you have an interest in a financial account or signatory authority over a financial account, you may have FBAR responsibilities if it is a foreign financial account. Essentially, we want to talk about what you do if you're not in compliance with the FBAR reporting responsibilities. Essentially, there are three programs that currently you can take advantage of. One is the Offshore Voluntary Disclosure Program, which we'll talk more about in a moment. The other is the Streamlined Filing Procedures. And the third is Delinquent FBAR Submission Procedures. Under any of these three procedures, you have the opportunity to remediate some of the problems that you've created for yourself by being non-compliant. Jim, I've heard recently that the OVDP program is going to end. Can you tell us a little bit about the implications of that?
Sure. The Offshore Voluntary Disclosure Program has been in existence in various forms since 2009. And I think we all felt that at some point that program was going to end. And we're just really surprised that it lasted this long. The Offshore Voluntary Disclosure Program, as it exists today, is designed for those who are willful non-filers of FBARs and income tax returns. And that program provides protection from criminal investigation as well as a set penalty under the civil statutes. That program is going to end September 28th, 2018. And what that means is that the parameters of a settlement, including the penalties, will no longer be set in stone. And so we'll revert back to where we were prior to 2009, which is if you have a situation in which you do not qualify for Streamline or the delinquent FBAR filing obligations, you'll need to pursue the IRS Criminal Investigation Division directly. Now, there is commentary out there whether or not there'll be a subsequent program, but right now it looks like we'll have to revert back to that policy, which there is no certainty with respect to the penalties.
Now, if you have not come in under one of the voluntary disclosure policies, my understanding is normally that you would come in through an examination, either a civil or criminal examination.
That's correct, Susan. So even if you were in the program and you opted out, or whether there was an examination opened, there are two different examinations that can occur. A civil examination of your income tax returns for your foreign accounts, as well as an FBAR investigation. The FBAR investigation is conducted by the IRS, and it looks into all of the facts and circumstances surrounding your account. So the fact that you may not have heard of an FBAR at the time that you were required to file one doesn't necessarily mean the audit ends. The IRS will take a look at your communications with your accountants. They'll take a look at your communications with the bank. They'll look at the way in which you reported your income on your income tax return to try to determine whether or not the civil penalty should apply, and most importantly, whether willful penalties or non-willful penalties should apply.
Well, I know that ignorance is not a defense, and I guess what you're telling me is that if you have not taken advantage of one of these voluntary programs, you're really going to get a very thorough audit by the IRS as to what you did do during that time.
That's correct. So there's a concept of willful blindness that the government has pursued in a number of cases, both at exam, at appeals, and in court, where despite the fact that the taxpayer has no knowledge of an FBAR form, surrounding circumstances may establish that prudent business review was not undertaken, and therefore the party is willfully blind.
Well, given the fact that that the OVDP program is going to end, what should people do under these circumstances?
Well, if they really should contact a qualified advisor to try to determine whether the programs available to you that exist, new programs that may come up are available, as well as determine if you're in litigation what steps you need to take under discovery, because it is a much different procedure than an income tax case in court.
Well, and I know that there's so much more availability of information by the IRS because of all of the reporting, because of all of the different types of reporting that occurs. So just because you didn't report it or you're not aware of it being reported doesn't mean that you won't be caught by this net. And so I think specialized experience is very important in this area. Can you tell us a little bit about, or share with our viewers, our experience here at Evershed Sutherland?
Sure. So we've seen cases arise from the streamlined filings, from the DOJ Swiss settlement, from FATCA submissions, from disclosures from whistleblowers, and disclosures from other taxpayers. So all of these sources of information are being used to determine whether or not a particular individual is compliant or not. So the end result is, if you're not compliant, there's ways to get in, and we're available to help you come into compliance.
For more information, please contact Jim or me, or visit our website at evershed-sutherland.com for more bottom line videos. Thank you.
Thank you.